amended motion to compel DNA bench notes, reports, and scanners, and if you will give me your thoughts, Mr.
Actually,
I'm going to handle it, Dr. Barrow. Thank you. That's okay, Ron.
Well, let me get us on the record, and then maybe there'll be a response. Your Honor, I'm Robert Guthrie, an assistant county attorney here on behalf of Orange County. With regard to item number 19, you have it, and we're gathering the materials that we have, that the county has as an organization. And that is an employment contract with Dr. Garavaglia and a contract with the Discovery Channel for the use of the medical examiner building. And then periodically we have other use agreements where a program wants to film on our premises. And so we can produce all those. We actually do not have the various agreements between Dr. Garavaglia and the Discovery Channel for her show. And she may well interpose an objection to those, producing those, but I haven't been authorized by the county attorney yet to appear on her behalf in that regard. So I'm fleshing that out. But as to the materials that are between Orange County and Dr. G, Orange County and the Discovery Channel, and Orange County and any other, most of them are independent producers that do medical shows, we can present those. I was going to go back 3 or 4 years on those. I think I can do it from a week from tomorrow. I've got the drafts and other things are what we're having trouble going back into our files.
By March 20th, you should have those defense counsel?
I do, yes.
You're not talking about any separate contracts that Dr. Garavaglia might have?
Correct. I'm not.
Just the ones that the county is part of?
Yes, sir.
All right. Defense counsel, you will speak with him?
Yeah, Your Honor, that's fine. If there's indication that he's not representing a person, that's fine. Right now, we needed the county contracts, and then we'll go from there.
Thank you. If you will, all right, let the record reflect that those will be produced by the county, and they will be to defense counsel by March 20th, by the end of business on March 20th. All right, and then let's talk about the motion for sanctions. It really goes sort of hand in hand with the other motion. This is more specifically, I think, regarding the reports or the workings of Drs. Haskell and Hall.
I will, sir.
Go ahead.
Judge, from, I guess, prior to us, once we arrived, I pretty much laid it out in my 13-paragraph motion, the facts that gave rise to what we believe has put us in the position where we're required to ask for sanctions. From all appearances, it looks like the state may call some witnesses. I'd prefer to leave my argument until after the conclusion of any testimony or evidence is presented. Procedurally, if that's how you'd like to proceed. If not, I can pretty much outline it for you.
All right.
Your Honor, this is an evidentiary motion. Mr. Baez is the moving party. It is incumbent upon him to produce some evidence in support of his motion. If he chooses not to do that, we ask the court to strike the motion. I have asked Mr. Baez on more than one occasion to withdraw this as moot, since obviously in his filing of it, it gives him notice of the items that he is claiming we failed to produce at some point. Nonetheless, we are prepared to cross-examine whatever witnesses he wishes to present at this time.
If that's the way it's going to go, Judge, that's fine. I'll lay out the facts as they are.
Your Honor, I object to Mr. Baez testifying as to the facts of this motion unless he wishes to be cross-examined on the matter.
This is a motion for sanctions, and you're indicating, certain things happened, and the state's asking for proof on that. One second, let me make sure I'm not overlooking something here. The other thing I would mention is, well, keep it right out. Can I have you come up for a second?
Sure.